Good morning and welcome to Flash Briefings by Manning Fulton. Today's topic, court operations and litigating cases in a post-pandemic world, is the fifth of Manning Fulton's Flash Briefings, designed to provide you with key legal insights in support of your business objectives, and to do so in a manner you can quickly digest. My name is Alan Dickinson, the Director of Client Relations here at Manning Fulton, and I'm very glad you could join us. It's my pleasure to introduce my colleague Mike Harrell, an exceptional litigator who will be leading today's session. You will have the opportunity to submit questions this morning by typing your questions into the questions pane of the webinar's control panel, and we encourage you to do so at any time during the presentation. If we are unable to address your question during the session itself, Mr. Harrell will contact you directly following the presentation. And with that, I turn it over to Mike.
Thank you, Alan. When Alan and I were discussing possible subjects about that I can speak on, we kept going back to just how court was operating since court reopened in June. I mean, when the pandemic hit in March, the courthouse, all courthouses in the state were shut down for 2.5 months with very limited exceptions. The courthouses have kind of reopened. Court operations have kind of resumed, but it's really changed, and I've litigated for 30 years, and I've never seen either the scope of change or the quickness of the changes as I have since then. So I just felt like it would be helpful just to explain to you what it's like these days to go down to the courthouse, or more accurately, a lot of times not go down to the courthouse while you're litigating your case. Now, with respect to the courthouse, the first thing is, if you want to get into the courthouse, you've got to comply with CDC and local ordinances. You may be the biggest anti-masker in the world. You may think it's inhibits your freedom. You're not getting in the courthouse unless you got a mask. So you got to wear a mask. You get in the courthouse. You go to the courtroom. The courtrooms will have different row benches taped off to try to promote social distancing. They'll only have a limited number of people in the courtroom. A lot of times what the courts are doing is you attend a calendar call online virtually at 9 o'clock. You're given a specific time to show up in court that day, and that's your time. So the court says be there at 3 o'clock. You're there at 3 o'clock. You got an hour. In terms of addressing judges or addressing other people, when the courthouse first reopened, some of the judges wanted you to take your mask off, and now they all want you to keep your mask on, which again, I think makes sense from a public health standpoint, but it doesn't help to promote understanding. It doesn't help to promote communication when you can't see what your opponent may be saying to the court and it's muffled. Or when the judge is asking you a question, you're not quite clear what the question is the judge is asking you. So it does inhibit your ability to communicate more effectively. In addition, you got to be very conscious of where you stand in the courtroom and where you stand in conjunction with your client and this, that, and the other. Two changes that I think are really significant and could have potentially a really dramatic impact upon cases that your business or you yourself individually may be involved in is right now, effectively, everybody has a get out of jail free card in terms of continuing cases. Now, historically, if you make a motion to continue a case, that motion is purely within the judge's discretion. So some judges are real prone to continue cases. Some judges aren't prone to continue cases at all. And but since the pandemic has hit, the Chief Justice of the Supreme Court has laid down an emergency order, which basically says, look, if you have any symptoms whatsoever, not just a fever, but anything, coughing or aches or anything that could be attributed to a coronavirus, you're not supposed to go to the courthouse. So you can have a circumstance, and this hasn't happened to me yet, but you can have a circumstance where you get all ready for court, you're ready to go down, of course, your client has invested a lot of time and effort and money in you getting ready for court, and your opponent says, I woke up this morning with a fever, I can't be there. And the court doesn't have any discretion to control that. I mean, under the emergency order, that case has to be continued. Now, I know it's hard to believe that some lawyers would be unscrupulous and would take advantage of that. And I hope that my opponents wouldn't necessarily take advantage of that, but I got to be honest with you. I think a few of them, because they don't want the case being tried, they may all of a sudden get sick. And by getting sick, they kick the can down the road. And then at that point, your client's invested a lot of time, money, and effort into getting ready for court, and you're not reached. I had a case continue, not because of that, but just because the way the court calendar worked just a few weeks ago, and it's very dispiriting for clients to be ready to go to court to invest that money and then not be able to go. So the other thing, which is really significant, I think, is that when the pandemic, when the shutdown first occurred mid-March, the Chief Justice issued an emergency order suspending all jury trials, which makes sense. That order is still in effect. The Chief Justice has asked the various counties and the chief resident superior district court judges to come up with protocols to conduct jury trials. But and I think jury trials are supposed to resume. Right now, the deadline is mid-October. I would not be surprised if that got pushed back farther. But the fact of the matter is that they don't really know how they're going to conduct jury trials. And because obviously it's very difficult to get 12 people in a jury box and socially distance them, or get them back in the conference room and let them deliberate and socially distance, and aside from all the other issues you have going on at the courthouse. So there haven't been any jury trials since mid-March. It's really significant in the criminal context because, you know, you have a right to trial by jury for almost any criminal violation you're charged with. We don't really do criminal stuff, but we do civil stuff, and a lot of times people will ask for jury trials. And as a matter of default, if you're representing a defendant, you almost always ask for a jury trial in some kind of negligence or breach of contract or whatever the case is. And the practical effect right now of asking for a jury determination in any kind of dispute is you don't know when your case is going to get tried. And meanwhile, the backlog just keeps getting bigger and bigger and bigger. I had a case I just filed recently on behalf of a client as a plaintiff, where the guy owned a place down at the beach, and they were digging in utility poles, and they punctured his septic field, and it ruined his septic field. So now he's got to spend, you know, tens and hundreds of thousands of dollars to correct that. And so he wants someone to pay for that. So we have filed suit. That is a suit that pre-pandemic, I wouldn't have thought twice about asking a jury for. I mean, it's a negligence case. Those normally are decided by juries. And but then in this instance, in talking with my client, I said, look, I'm just going to ask for a judge trial because I don't know when we're going to have jury trials again. But I also explained to my client, I said, let me say this. If the lawyers representing the defendants don't ask for a jury trial, they're committing malpractice. Because if you're a defendant, you know, obviously the longer you can delay something and drag it out, the more likely it is you can wear the plaintiff down to a point where you can reach some kind of settlement. So I fully expect the defendants to ask for jury trials. I'll be shocked if they don't, but we don't know right now when jury trials are going to resume, and we don't know how they're going to resume. I've seen some stuff where they're talking about moving the jury trials to like some big community center where the jurors can space out and comply with CDC guidelines and local and state guidelines. But how you conduct a trial in that scenario is really an open-ended question. A lot of people are spending a lot of man hours trying to figure it out, and I don't know if anyone's figured it out yet. And I'm not convinced anyone's going to figure it out. So the bigger change with respect to how the pandemic has affected court operations is probably, this is just anecdotal based on my experience, 75, 80, 85%, maybe more of all hearings have moved online. Now, to reiterate the point, I started practicing with Manning Fulton in 1990. I've always been a litigator. They sent me down to court the first month after I got my law license. It wasn't this, I need to kind of ease into this. So I've been going to the courthouse for 30 years. And prior to March of this year, I never had a single hearing online in any capacity that I can remember. And after the pandemic hit and after the courthouse shut down in mid-March, I've probably had, I don't know, a half dozen or more hearings online. Now, that entails a couple of things. I mean, that entails learning how to use Zoom, learning how to use Microsoft Teams, all stuff that I really didn't have any familiarity with. And not that I'm an expert in it, but certainly I know how to operate it now. But just the dynamics of arguing stuff to a computer screen versus in a courtroom, and arguing against opponents on other computer screens, on your computer screen, is a whole new world, and it's very different. And quite honestly, some of it is good, and some of it works for the benefit of your client. For example, I had a case recently where my client was located in California. It was down in Moore County. I went down to Moore County to personally appear in the clerk's courtroom, but my client was able to participate online on the computer from California. So my client didn't have to bear this expense of traveling from California to come to North Carolina, of course, dealing with the issues about public safety and the pandemic in the airport, or going flying, or any of those. So that was a real savings for my client. You know, it's nice to be able to get up in the morning, and instead of worrying about running around to get ready for court, be kind of leisurely in terms of just making sure that, if you know, be on the flash briefing at 8:30, or you know, be on the counter call at 9 o'clock, and of course clients aren't paying for all this running around and prep work. So there are some things that are advantageous in terms of doing stuff online, but there are a lot of things that either they're not advantageous or yet to be determined. So one of the issues that you have when you're presenting a case online versus presenting it in live courtroom is how you handle exhibits. I mean, in the courtroom, you just copy your exhibits, or you may have an exhibit notebook and you hand that exhibit notebook up to the judge, or you provide copies to everybody as you go through the exhibits. And you may be pretty, the way I operate is I'm pretty organic. I have a list of exhibits, but I don't necessarily know exactly which or all of them I'm going to use. So just as the circumstances dictate, I may use some, all, or very few of them. But if you're presenting something online, you've got to have the circumstances where you've got all your exhibits identified, marked, and able to be disseminated to the court in some kind of electronic fashion. So if you're not doing that ahead of time, and a lot of the judges don't necessarily have protocols for doing it ahead of time, then you're presenting it to them by email during the course of this virtual hearing you're having. The bigger issue, however, that I have encountered is issues with witnesses. So if you are cross-examining a witness in the courtroom, then obviously the judge is right there, the witness is right next to them. Your attention is focused on the witness. The judge can view, you know, the witness in context of not only what the witness says, but his or her body language and all kinds of nonverbal cues that may help the court determine the credibility of the witness. Well, that's a whole new world when you're dealing with someone on this little computer screen. And there are any number of ways that witnesses can, cheat. I mean, for example, one of the things that can happen is, this is a very common thing pre-pandemic. You've got a client, your client wants to go on the stand, you've prepped your client with a bunch of questions, and your client says, well, can I take this, whatever this is, a document or a notebook or a series of documents, can I take this with me to the stand? And typically, my advice to those people is, no, don't do that, because it's going to look like you're reading your testimony. It's going to look like you're being coached. It's going to look like that you're not familiar. And I go, to the extent you don't remember something, just indicate that you don't remember it. But I think you're going to have more credibility with the court if you're on the stand testifying without a series of materials to help your, to rely upon. And also, just from a practical standpoint, I have a card here, but which just has a few notes on it. But basically, most people, if they have something in writing, they're going to look at the writing versus looking at the questioner or looking at the judge. So what do you do when you are examining a witness online and all you see of the witness is this box, okay? Because the witness, not only could the witness have a card underneath the view of the camera, but the witness could have someone sitting next to them, sending them materials or texting them responses on their phone or any number of things. And literally, I don't know about it. I had a hearing about a month or so ago where, and this is very common too, where, people are literally, potential witnesses are sitting next to each other, which they can't do in the courtroom, but it's a husband and wife. They're both parties to the action. And the husband is quote unquote on camera and the wife is off camera. Okay. And the husband's being asked all these questions. And at one point, the husband was asked a question, which was a difficult question by one of the lawyers. And all of a sudden, the wife off camera goes, no. And so, if she had written that down versus just blurting it out, she could have put a no on a card or texted the guy no, and he could have been coached as to what the answer was. So there can be a lot of shenanigans in terms of coaching witnesses or witnesses corroborating with each other or getting information through each other, etc. Another problem you have is witnesses not understanding questions. Now, it's one thing when you're in a live courtroom and you're asking a witness what they deem to be, or what you deem to be rather, a simple question, and they struggle to answer it. It is possible that the witness doesn't understand the question, but more likely than not, the reason why they're struggling to answer the question is because they don't want to answer the question. So, and again, because you're in the courtroom and the judge can witness the witness's body language and nonverbal cues and all that. Hopefully the judge gets the sense that, well, the reason why the witness is not answering this question is because they don't want to answer the question because it's a difficult answer for them. So what do you do when you're online litigating a case and the witness says, I didn't understand the question, or you broke up there for a minute? Because the fact of the matter is that you do break up on the Wake County, not the Wake County, the North Carolina state court system uses WebEx. And I don't want to get into, whether WebEx is better or worse than Zoom or Microsoft Teams or any of the other platforms. But the fact of the matter is that occasionally people break up, or occasionally someone has their microphone on, and so there's echo, and it starts doing that reverberation thing where you can't understand anything. So, there are legitimate technological issues which may prevent a witness, or for that matter, a judge or opposing counsel, to understand what you heard. But also, those technological issues are very conveniently a crutch on which the witness can rely upon to say, I didn't understand your question. So, you know, you don't have the ability like you would have in a live courtroom to, you know, bear down on the witness and say, okay, let me spell it out for you very slowly and clearly, because the witness may or may not be having difficulty with understanding the question because of the technological limitations. So the other thing about witnesses, and I touched upon this earlier, but is if you've got someone sitting like I'm sitting in a chair looking on a computer screen, I mean, I still gesticulate a lot, you can see that, but you're not really getting any of the nonverbal information that we rely upon. I mean, there have been social science studies that indicate that we get as much as 80 or 90% of our information based upon nonverbal cues, depending on the circumstances. So that is not completely eliminated, but you know, it's mostly eliminated when you're looking at somebody from the shoulders up. And you don't have any of the information about how that witness is responding in context. And then another thing that happens is that, you know, people don't always look square onto the camera. I mean, sometimes they're, you know, they've got their camera here because they've got their phone here, and so you're not even getting a situation where the witness is looking at you directly for you to get whatever, you know, little nonverbal information you can get from that witness. So and what has happened in terms of the court system, and going back to this backup, which has happened, which I talked about earlier, is that initially I do a lot of domestic stuff these days because no one else in the firm does it, but initially in domestic court, the rules were at the beginning of June, the only thing we're going to have online is we're going to have oral arguments, legal arguments, where there aren't any witnesses being examined. Well, that lasted about a month and a half. And then after about a month and a half, they said, well, we could have temporary hearings. We can have temporary hearings about a certain length, a certain amount. And now they've just gone to pretty much anything that the parties agree to be tried can be tried. So I've got a question here. It says, how can one get a more predictable courtroom experience? Do you advise postponing all matters until courts are fully operational? Can that be done? Move to arbitration cost, okay? And that's a great question, because I actually was going to possible alternatives towards the courtroom system. So the truth of the matter is that I mean, the pandemic has rendered everything uncertain in terms of quote unquote when things get back to normal. So the problem is that when you're representing clients and you're trying to, because clients obviously are like, okay, well, Mike, you know, I appreciate all these problems, but you know, I don't like all these problems because these problems increase uncertainties, and by increasing uncertainties, they increase costs for me. When do things get back to normal? And the short answer is nobody knows. However, there are certain things that you cannot do to avoid court if you don't have those things in place already. For example, if you have a contractual arrangement with somebody, and that contractual arrangement does not have like a binding arbitration provision in it, and there's a breach over the contract, or alleged breach, and you're sued for a breach of the contract, you don't get to push that case into arbitration simply because you want to. I mean, if you don't have arbitration provisions in your contracts and your contractual documents, then you don't get the option of going to arbitration. You don't get the ability to push a case out of the court system. So, I mean, let me put my salesman hat on. You know, if you don't have those arbitration provisions in your contracts, get them, okay? And let us rewrite them for you. Not me, but there are other people in the firm that can do that. But there are certain things, if, like I said, going back to that example I gave earlier about the utility pole, that's a negligence action. You can't arbitrate out of that. The parties can agree to arbitration, but if all the parties don't agree to it, that stays in the court system. So if it stays in the court system, because that's that's where we had to file it. There was no people don't have arbitration provisions for if I injure you a year from now. I mean, it just happens and the suit arises. As far as moving to arbitration, I mean, obviously arbitration in and of itself has cost to it that the court system doesn't have. For example, you got to pay for, if you have one arbitrator or if you have 3 arbitrators, you are paying for the cost of you're dividing the cost with the other parties of the arbitrator or the panel of arbitrators. That could be a significant expense. If you have administrative costs to file with different arbitration organizations. I've filed 2 arbitrations in the past couple months, and one of them, the amount of dispute was about 150 grand, and the filing fee for that is going to be about $4,000. Okay, that's the administrative cost. That's not the cost for the arbitrator, which we got to pay. Normally, arbitrators a retired judge or a private lawyer, and you're dividing the cost of that. There are and there can be significant cost to arbitration. However, with the arbitration, you control, or not necessarily control, but you have influence over when stuff happens and how it happens. And I have participated in, I haven't done any arbitrations yet, but I've done a number of mediations online where, where everybody is in their own, virtual reality, but we're still able to meet electronically. And participate, and in most of the cases get them settled. So whatever you're paying on the front end in terms of the arbitration costs, administrative costs, etc., maybe and hopefully you're saving on the back end in terms of the uncertainty of the example I gave earlier, where you're spending all this time getting ready to go to court, all this effort and money getting ready to court, and then you're ready to present your case and you're pushed off the court calendar because of the backup in the court system, or because the other side has a fever or has aches or is coughing or whatever. So these are difficult questions, and I'm just now filing arbitration actions in those cases where I have arbitration provisions in the contract, precisely because I don't know when this stuff ends. I don't know how. I mean, hopefully I know how it ends. Hopefully we all get a virus. Not get a virus. Hopefully we all get a virus. I'm not a herd guy. Hopefully I'll get a vaccine, and it'll take care of the virus, and we can live with it like we live with the flu and polio and everything else. But there's no time frame for that now. So if you can build in certainty at the front end, whether that certainty is through contractual provision, to the extent you can have arbitration provisions in your contracts, or actually either through a contractual provision or just by the agreement of the parties. I mean, your opponents also want certainty. They also want certainty in cost and time and all that. Then you may want to push stuff into the ADR realm. And I'm looking at, I don't know if my clock's right or not, but I'm looking at my clock. I know we're supposed to end at 9 o'clock. So unless there are any other questions, I think my contact information is on the flash briefing card. If not, it's Harrell, Harrell at manningfulton.com. Feel free to send me an email. I do a lot of emails these days because we're in a pandemic, but I appreciate everybody's time and attention. I appreciate the opportunity to be able to at least impart a little information to you all about these issues.
Thank you, Mike, and thank you everyone for attending today's webinar. Again, if you have any questions regarding the information presented, please feel free to contact us and Mike specifically, and we'll be happy to discuss them with you. On behalf of Manning Fulton, we wish you a fantastic day.